May I please, Lordship? I beg to mention item number 3, Lordship. Kindly take up after 2 weeks, Lordship. I have to file an additional affidavit.
You have already filed or you're going to file? You have
Not filed,
already
Lordship.
filed.
No.
You're going to file.
Yes, Lord.
You are Mr.
A.S. Ali.
Part Mr. A.S. Ali, the learned counsel petition. Part Sage Bora, the learned additional opinion. Mr. Ali seeks for an adjournment, stating that he is going to file an additional affidavit. Considering the prayer made by learned counsel for the petitioner, leads the matter. After 2 weeks, you need?
After 2 weeks.
After 2 weeks. You want any date fix here?
No.
After 2 weeks, as any date. Okay.
Subject to mention item number 6, my lord. The charge sheet matter, my lord. Noxo matter, my lord.
Yes. You have
The
received a
person-
scan copy here.
Yes, my lord.
Ah.
Scan copy has been received, my lord, but I cannot go through, my lord.
Someone is appearing for respondent number 2 also.
Yes. On the last occasion, they have appeared, my lord.
Sir, notice is duly served upon respondent number 2, Lordship.
And then they are appeared also.
They are appeared.
Names
They
of
appear,
people
but today they are
counsels are
absent.
there.
Yes.
You need some time.
Yes, my lord.
But
So
Mr.
whether the deposition is there or not, my lord, I'm not sure about the victim deposition is there or not. They have recorded or not.
Certificate.
That's it 2 weeks before.
Lordship, then deposition will not.
On be there.
Probably may not be there.
Up to
It's
that,
not there, Lordship. I
Yes.
have gone through it.
yes, my lord.
Okay.
The deposition is required, my
Certificate
lord.
is filed just before 2 weeks, as my learned
Yes,
friend has stated. So Lordship may call for the up-to-date.
my lord.
Then it may be yes, up
Yes.
to date, maybe with the present status.
Yes, my lord.
Let
But
it be
Mr.
come in the
Igor-
month of January, Lordship, because only Certificate has been filed just now, before 2 weeks.
Okay. But Mr. Deborah, the learned counsel petitioner, also part Ms. Sage Bora, the learned additional PP appearing on the status. Names of 4 advocates are being shown in the cause list for the respondent number 2, but none appeared today. As per the request made by the counsel for Mr. Deborah, matter is adjourned. List the matter accordingly.
First week of January.
January. 7th of January. 7th of January.
Of late.
Deeply
And further, the registry is thereby directed to call for the present status of the case along with the evidence of PWs. If any,
Certificate.
if any.
Obliged.
Yes, Lordship.
Please, Your Lordship. Here in this case, earlier your lordship directed the trial court to conclude the trial within 6 months. That observation your lordship will find page 113. And that 6 month will expire on lordship 17 December. So at this stage, my prayer is that records may be called for and may be fixed on 18th lordship.
This was the case of that murder and
Yes,
photo
Lord.
and all.
Yes.
Part Mr. A. Ahmed, the learned counsel for the petition. Part Sage Bora, the learned PP appearing on the status. All for the scan copy of this year along with the present status report. Then if it is in 17 December, then
Lordship will
let it
fix it
be
on 18th.
after
No, the trial court date is on 3rd.
Fine.
On the trial court date is on 3rd. But your lordship, that 6 month period which your lordship granted, that will
understand.
expire on 17th.
17.
Yes, so I
You
am
want to
praying for
fix it on 18.
18th Lord.
Okay. 8.
Obliged, Lordship.
May I, Lord?
Please.
Please, Your Lordship. Lordship 482 bail application. Lordship may peruse the FIR, translated copy.
Just a second. It is
Lordship,
earlier
it was rejected. Yes.
Yes, sir, Lordship.
If it is earlier rejected, maybe after appraisal of the case, I don't know. Just I'll see.
And-
the
But
record.
your
Whether
Lordship,
my
Probably
learned
case
friend
there
has
he was-
taken any.
but your Lordship, the name accused has been released on bail, Your Lordship. regular bail, Your Lordship.
It's earlier rejected by this honorable court, Lordship. Whether my,
Rejected, or I don't know, one order of one co-accused is you have annexed.
Lordship, I have annexed, Your Lordship.
You have annexed one order of one of the co-accused.
Yes, Your Lordship.
And what about your petitioner? Or was it,
Well-
it was the petitioner, it was rejected
Lordship, 15/7/2025.
on 15/7.
Lordship. It starts from page 67. It was rejected by the honorable.
Lordship,
Now see, the earlier you have annexed the bail order of co-accused, one co-accused.
yes, sir.
But the question is that was BA.
Yes, sir.
And considering most probably his length of detention, that was considered.
Yes, sir.
But your one is AB, and that is why your AB was earlier rejected on perusal of the case diary.
Yes, sir.
There may be some address, I don't know.
Yes.
Exactly, I cannot remember now.
But Your Lordship,
So let the case diary be called for, otherwise it may not be possible. Yes, any other submission from you?
Lordship, I've only introduced the informant to the accused as the contention of the FIR reveals that I have introduced the informant to the accused named Mintu Deka. But Your Lordship, let us assume, but not admitting the fact, introduction of a person that does not mean that I am wholly involved in or I am involved in this scheme, Your Lordship. I am the victimized person, Your Lordship. I have paid a total sum of 3,42,501 rupees, Your Lordship. Lordship may kindly peruse page 29, Your Lordship. The transaction part, Your Lordship. Lordship, 32, page number 32, Your Lordship. 25/6/2024, I have paid rupees 1. 25/6/2024, I have paid 30,000, Your Lordship. The whole amount I have paid 3,42,501, Your Lordship. I'm the victimized person, Your Lordship. I'm falsely implicated in the case, Your Lordship.
In the earlier occasion, Lordship is pleased to reject the bail petition after having sufficient materials against the petitioner. Lordship. So at this stage, whether my friend has taken any new ground, Lordship?
He has no new ground.
Then-
You don't have any new ground. Same, on the same ground it was rejected.
Because there's a
Now see, your purpose is not only to introduce, your purpose is introducing those candidates along with the co-accused person within conspiracy. You have misappropriated. That is the reason why you are introducing so many candidates to that the other co-accused. Look, it is not a case that your part is only for introduction or introducing. It's not a case.
Lordship,
As I don't know, as per my observation in the last order.
Lordship, I'm ready
So
to.
now you don't have any new ground also. Let us see, at best we may call for the case diary to
Yes,
see
sir.
the progress
Lordship,
of the
I may be
investigation,
protected.
that much.
not
I
at
may
this
be
stage.
protected, Your
No, you cannot. You cannot be protected. Your bail application has earlier been rejected. At this stage, question of protection does not arise. Your petition itself is not maintainable unless
Yes.
and until there is any urgent new or any ground.
Not.
It seems that there is no new ground. It is outrightly to be rejected, but however, we want to see the progress of the investigation.
Yes, sir.
And obviously, there is no bar at all to file your subsequent bail application. That cannot be a bar. You can file.
Okay.
So we may call for the case diary at least
Up to date.
up to the case diary. When it can be fixed, done.
Lordship, can it be on 16 December?
16th of December. Yes, it can be. Okay.
Highly obliged.
Obliged.
Yeah, please, Your Lordship.
So we have received your scan copy. Na?
Lordship, yes, we have to get a scan copy, but as per office, no. That is
So is
24/11 services evicted.
Oh, it is a POXO. Oh, acha. Then can you, because
My lord, just go through these 4 lines, my lord.
basically you take grounds of arrest, not communicated.
Grounds of arrest not communicated.
Mm.
And 1 year, 11 month, 5 days. Out of 10 witnesses, only 3 witnesses examined.
Mm.
And there were 5% apprehended, 4 were granted bail.
Mm.
And my lord, will kindly turn to page 68 of my petition. 67 is the bail order, 67 and or 68. 67 is the post title, 68.
68.
The order starts from 68. My lord is there?
Mm.
Same. Only the name is different. Preposition, conjunction, everything same. Same case. Not only page 68, also page 80. Because these are the co-accused. My lord is there as 80 and page 90, the other co-accused. Page 90. Everything same, my lord. Not even one word here and there except the name. Same day, same vehicle, same contraband, same ground of arrest, same documents applied to everyone. So I have three major grounds. One is prolonged incarceration, 1 year, 11 months. And this petitioner case is better because he has undergone more sentence. 1 year, 11 months, prolonged incarceration, ground of arrest not communicated. And number 3 is on parity. So on these 3 grounds, I am praying for them. That's my case, my lord. I will not.
Lordship, here parity cannot be the ground because Lordship, here this rule is different. Lordship, contraband recovered from him, he is a habitual offender. Lordship, he is involved
Contraband recovered from him.
from his position. But Lordship, one more thing, he is a habitual offender. He is involved in 3 cases. Lordship.
Yes, what are those cases?
And Lordship,
Hmm.
and
3 cases.
3 cases. He is a habitual offender. I don't have Lordship NCP crime number. Lordship, I will place after some. And Lordship, at the time of his arrest, he accepted arrest memo. Lordship, in arrest memo. Lordship, everything was there. Lordship, he was caught red-handed. Lordship. And Lordship, I'm relying when Lordship of coordinate bench. Lordship may consider. And Lordship, prolonged incarceration cannot be the ground. Lordship, recently one judgment by us Union of India versus Namdev Asurba.
Even the yes,
और बात को तरफ करते हैं बस
You rely on basically para number.
Lordship in Namdev Lordship, Lordship, I have flag mark Lordship 13, 12, 13. Namdev judgment Lordship.
Update to 12,
12, 13 Lordship.
12 and 13.
12.
Oh, my lord. May I indicate that she has made submission without reading the brief, my lord? I'll just show, my lord. It is not her fault because they have many cases. Probably they have read some other brief. What she said, that contraband was recovered from me. So the impression given to the court is that that is precisely what she submitted. She cannot now, my lord. She said that the contraband was recovered from me. So an impression was given as if the other co-accused, from them it was not recovered. Kindly come to page 16 of their document. Page 16 of this. So, my lord, this is what happens when, my lord, people don't read the brief and make submission. I'll just indicate from their document.
1-6.
1-6, my lord. Kindly. Para number 6, if your lordship kindly come. Page 16, para 6, my lord, is there, my lord?
Just
That thereafter Mahesh Prasad, inspector, along with NCB Guwahati team and 2 independent witnesses started surveillance in that area on such and such at 2 p.m. A red colored Hyundai car bearing registration number such and such was seen coming from Jagi Road side. The said car stopped at Shonapur Toll Plaza. Mahesh Padar, inspector of his team, and both the independent witnesses were near there. There were 5 persons in the car. So out of this 5%, 4 persons are granted bail. 3 by the Honorable High Court, 1 by the trial court. And they have not filed any application for cancellation of such bail. No application. Even the trial court have granted bail to the 4th accused after going through your lordships, the 3 order. They even did not challenge the trial court order because this high court order. Simply coming and saying something in the court, that too verbally. They filed a written statement, written objection in this case, my lord. Did they anywhere mention about my involvement in other cases? Answer is no. And my lord, mere involvement will not do, my lord. Mr. X name, somebody may put in 1,000 cases. But whether he has been implicated, convicted, or all those cases are also of the similar nature, we do not know. A submission is made in vain. This is to tackle her second point. The third point, the judgment, the 2 orders which he relied on. My lord, to whatever little I understand, my lord, these are order passed in bail application. These are no precedent. Because, my lord, on Supreme Court says even one fact here and there makes a hell of difference in the conclusion of case. Because in that case which she has relied, in those cases, co-accused were not granted bail. There were no question of parity. And in these cases, identical, absolutely, because I have demonstrated, because all of them were on the same car. And they were supplied the same sort of documents. That memorandum of arrest which they are speaking of, your lordship has observed that those memorandum of arrest are general in nature. It does not say what offense somebody has committed. Those memorandum of arrest, my lord, simply say that the contrabands are liable for confiscation. The contrabands are liable for confiscation, and accused is liable to be punished under section 8C of the NDPS Act. Now, my lord, 8C of the NDPS Act contemplates 13 different types of offenses. And your lordship, when, my lord, because in one of the cases I argued, I still remember it is recorded in that judgment also, your lordship has, after going through section 8C, have observed that 8C comprises of different sub-offenses. And there is no... in this case, that is precisely one of the co-accused. Well, in this case, while I was arguing for one of the co-accused, that memorandum of arrest was, they tried to project that memorandum of arrest to suffice the compliance of section 50 of the CRPC, now 47 of the BNS Act. Now, that memorandum of arrest simply says that you are liable to be convicted under section 8C. It does not say what role you play, because 8C takes into account transportation, possession, export, import, everything. So your lordship observed that this is a very vague sort of a ground of arrest, because it does not specify what specific role he played, and therefore this will not satisfy the condition of section 50. Very rightly, your lordship has observed that not only section 50, which is violative of article 22, sub-article 1. So that is my case. And one of the recent law is more harsh against that. The recent that Shah law, it says that it will not just communicate in ground of arrest. You will have to communicate in the language he understands. And there has to be a noting to that effect. It is just because the recent law, this Mihir Kumar Shah, that is more stringent. Is it 21 cannot be tickled with so lightly? Is it just formality's sake? Somebody comes and puts because I have come across their memorandum where there is this thumb impression and it is written in sophisticated English with all these sections, subsections. Supreme Court says it will not suffice. You explain him in the language which he understands, so that we give some meaning to the requirement, so that the Constitution does not become a mere formality. Some meaning has to be attached, my lord. Somebody comes from a village, what English he will understand? 8C section 37 NDPS, he will not understand anything. The Supreme Court will explain him. So I'm not on all these things, because if they argue, I can argue, I'll give a judgment of this. I don't want to burden the court with all these things, because this case is squarely covered by the judgment, which is at page number 67, Babla Mia. I'll just quote one paragraph of that judgment where your lordship has. Yes, yes. My lord, may kindly come to page 69, para number 7. This was my submission regarding their memorandum of arrest. My lord is there, my lord? Yes. The counsel, he further submitted that the claim of the respondent that the accused was provided with sufficient ground of arrest through the communication of the memorandum of arrest is untenable. He contends that the said memorandum of arrest does not specify the offense allegedly committed by the accused petitioner. It merely states that there is a prima facie case to proceed against the petitioner under section 8C, read with section 22C and 29 of the NDPS Act, which according to him does not constitute specific compliance with the constitutional mandate. These are my submission and your lordship's observation. I'll show, my lord. This is a page, para 17. Okay, para in the event. No, not 17. Yes, yes. Para 16. Your lordship will see. This is the finding of this. It is evident from the memorandum of arrest issued to the accused that it mentions the recovery of the contraband and states that there is a prima facie case against the accused under section 8C, read with such and such. However, it is a fact that there is no specific mention or detailed description of the alleged offense communicated with the accused petitioner. It is also an admitted position that section 8C of the NDPS Act encompasses various types of offenses, but the memorandum fails to specify which particular aspect or sub-offense under 8C is being invoked in the present. So therefore, my lord, all these things will not hold water in the present case. Maybe in some other case, they may make all those submissions. That's my simple thing.
Submitted. Other co-accused persons are not habitual. He is the habitual. This is my submission.
He is the habitual.
Oh, my lord, I got her point. She is now, this is not fair on her part. Okay, anyways, my lord, now I got her point why she's saying. This man was implicated, my junior just now informed me, was implicated in another case, same nature. There also he got bail by Honorable Mr. Justice Nidul Kumar Kolika. That order is also there. Because, my lord, there is a tendency among police officers. Suppose if there is some pending charge sheet and they cannot find the accused, they'll immediately link. They will arrest one person, and especially it happens with car thief and bike thief. They will have 50 cases pending, and one they will catch. That case also he has got bail. If your lordship wants, I can give the bail number. On the similar grounds, same sort of reasoning, that memorandum of arrest will not pay. That is, oh, I got you. But you bail that is BA number 2887.
BA?
BA 2887 oblique 2025. He is already been granted bail, wide order dated 25/9/2025. September or possess 25/9/20. That's right. Sir, I'm greatly okay.
He got bail only for non-compliance with section 6 in the other case.
What more ground is one? I'm deeply aware. In that case also, they made similar submission that there is another case pending, but the judge said, if constitutional provision is not complied, I cannot do anything. I'm deeply aware.
The type of order. Not the kind of order. The present status now we have.
My lord, that is, my lord, status was called for, my lord.
Ah.
My lord, we receive a status from the learned parenthood, my lord. But in the status, my lord, it is stated that, my lord, that is the his diary, my lord. May kindly produce the status report. I have flag mark, my lord. নতুনকে যেটো আহিছে দুটা ফাইল আছে নতুন ফ্ল্যাগ কৰা হয়
Case diary is not.
My lord, case diary not available, but my lord, charges frame, my lord, is the, my lord, depositions were made, my lord. But my lord, that is the, it is.
When the charge sheet was filed, it should accompany you with
Yes, my
this.
lord, and my lord, without having the, my lord, that is the, my lord, the case diary,
Ah.
because where the, my lord, the statements are available, my lord.
Ah.
Now, my lord, the other part, my lord, deposition, because in the cross also, if,
It will be required.
exactly, my lord, that part is required. Here, otherwise, my lord, three numbers of witnesses were examined, my lord, PW 1, 2, and 3. Those depositions are available. But, my lord, as because we don't have the case diary, and secondly, my lord, the search sheet is only available with us, we didn't get the detail. And even, my lord, if my lord produce the, my lord, the FIR also, that will not, my lord, clearly, my lord, all the things are not narrated in the FIR, my lord. Whether these are the Cesar witness, other things are there. For that reason, my lord, CD is required. Now, my lord, out of, my lord, there are total numbers of PWs in the, my lord, that is 9 numbers of PWs are there. And as per, my lord, that is the, my lord, available with us, my lord, that is the 3 numbers of PWs were examined, my lord.
In case of my case, only three Caesar witnesses were there. So all the three witnesses were examined, Your Honor.
My case means I could.
In my Caesar list, the vehicle which was recovered from the premises of the petitioner, in that case, only three witnesses were there, independent witness, Caesar witness. So all these three witnesses were examined, Your Honor.
This is otherwise a case of NDPS.
And
Yes, Lord.
NPPS, my lord, commercial quantity, my lord, earlier, my lord, two, my lord, that is peddlers were, my lord, arrested. On the basis of their, my lord, that is the clue, my lord, they make a search, my lord. Now, from the, my lord, the present accused petitioners, from whose residence, my lord, a, my lord, vehicle was there. From that vehicle, my lord, contraband, my lord, recovered 11 cartoons, my lord. So now, my lord, it is not a case that, my lord, only one case, my lord. Entire things come out as a whole, my lord.
Obviously.
Yes, my lord. So for that reason, my lord, CD is very much required, my lord. Because, my lord, the case, my lord, we have, my lord, we now available, we have the only, my lord, that is the search sheet, my lord. And, my lord, going through the search sheet, my lord, it is not, my lord, possible to, my lord, find out entirely.
How this status report is, how did that this
My
kind
lord,
of
that I
report
also,
be-
my lord, confused
If-
without having that, my lord, how
Should
depositions are going on, my lord.
And yes.
Trial is
case
going
report
on, my
would
lord.
be very strange. How
Strange, my
how
lord.
case will
One,
proceed?
my lord, direction should be there, my lord. We also make an intimation to the, my lord, that is the police station, my lord. Because they clearly stated that during that time, my lord, city was not produced. It is in that line, my lord.
Oh, definitely. And then how the PW 1, 2,
Yes,
and
my
3
lord.
were examined?
How, my lord, trial is going on, my lord. And then
That's
in a commercial quantity, NDPS matter, my lord.
Additional District and Session Judge Nogam. Very strange.
Very strange.
Before if submitting this kind of report, status report,
My lord.
the court should have make an inquiry. In fact,
Yes, my
how the city
Yes,
is
my lord.
lying before
Yes,
the
my lord. How the
concerned
trial
police
is
station or whatever.
how it is going on.
Otherwise, it has been misplaced, or
Yes.
there may be some intentional
My,
factor may also be there.
my lord.
How it can be misplaced?
So, my lord, I flag marks, my lord.
Now, see, question is that how long your petitioner is in custody?
Since April, Your Honor. 19th of April 25.
19th of April.
After
25.
after your order, Your Honor.
My lord,
You have-
earlier
you have
day,
directed-
he
you
has
have
directed this
directed
honorable
to-
court by way of filing, my lord, pre-arrest bail application.
Acha, acha. You have
As
signed.
per your direction only, the
You have signed.
petitioner, he surrendered and he was taken into custody. And since then, he was under in jail, Your Honor.
Now, see,
so
Mr.
far the
Counsel,
vehicle
question
which
is
was-
that
Which was
obviously
seized.
you are saying that your vehicle was seized
No,
in presence
it
of
was not my vehicle. It
no
was not
whatever
registered.
your vehicle.
But it was
You're
parked in
not
front
your
of
but
my-
the
in
vehicle
front
was
of
seized
my-
from your house or from your position, where from the contraband was recovered.
Not
So
my,
it's
not
not
my
a-
position.
Pardon?
It was not from my position. It was parked in front of my premises, Your Honor.
Then what
I
is your
don't have-
answer?
Yes, Lord.
How you what is your
Because-
answer? What is
because-
your plea?
Because that vehicle was not registered in my name. It was parked in front of my house.
Ah.
So because of the two accused who were arrested, so they lead to this particular spot, and from three places they have recovered this cough syrup.
Obviously, you may have a case. I won't disagree with you, but the question is that you cannot say that the 3 PWs which were examined, which have already been examined, are the
Yes.
Caesar witnesses, and these are the only witnesses in your case. That cannot be.
My lord.
Because as
No,
in
other
the case of
witnesses, they
commercial
are
quantity.
official witnesses, Your Lord.
Huh?
They are official witnesses. Rest.
Yes, rest official witnesses. How you have been linked with this case? Because now say you may be innocent. I'm
Yes.
just saying you may be innocent because parked vehicle may park in front of your house intentionally by someone or uh, keeping distance. They most probably they fled away from so and so. That may be
Yes.
one of the cause. But the question was unless and until you go to the case diary, what is there, how you got implicated in this case? Because you got implicated in this case and you have already been charged in this case.
Yes.
So there may be some link, there may be some, maybe from the statement of the co-accused also, we are not saying that. But the question is that you got implicated in this case. So against you, there is a case of commercial quantity, isn't it, at present? So we have to see the case
Yes.
study now. How can you
Yes,
say?
my lord, that is the FIR is also, my lord. In that respect, my lord, not very clear. Only may I read, my lord, only my lord, relevant part, my lord, from the particular. My lord, only the relevant part. সন্মানপূৰ্বক বিনীত নিবেদন এই যে নগাঁও সদৰ থানাৰ অঞ্চলত ইমান তাৰিখে এক গোপনীয় সূত্ৰৰ সংবাদৰ ভিত্তিত আমুক গাঁৱৰ চহৰত আব্দুল কায়ুম আৰু মহম্মদ আমুক আলীৰ পৰা নিচাযুক্ত সামগ্ৰীৰ অবৈধ ব্যৱসায়ী দুজনক কৰায়ত্ব কৰি সোধপোছ কৰা তেওঁলোকৰ স্বীকাৰোক্তিৰ ওপৰত ভিত্তি কৰি তেওঁলোকৰ লগত গৈ দেখুৱাই দিয়া মতে অত্ৰ থানাৰ অন্তৰ্গত মাছতিথিৰ আমুক গাঁৱৰ পুলকজ্যোতি কলিতা প্ৰেজেণ্ট একিউজ পিটিচনাৰ ঘৰৰ চৌহদত ৰখা ছো নাম্বাৰৰ টাটা ইণ্ডিকা গাড়ীখনত মজুত ৰখা 11 কাৰ্টুন ইমান নিচাযুক্ত সামগ্ৰী. So it is like that, my lord. And my lord, regarding that is the Caesar witness. In some affair, my lord, it is very clearly stated that we give the notice. These are the Caesar witness, SARS, and all these things. These are not mentioned in the, my lord. That is very, my lord. It is short way, my lord. Because of that, my lord, that is the, my lord, the difficulty we are facing, my lord, to make our submission.
Heard Mr. S. Tekari Learned Counsel for the petition. Heard Mr. K. Busher, the Learned Additional PP, appearing on behalf of SIS. State respondent. Scanned copy of the TCA has already been received, and as per in view of in person to order it is 17/11/2025. The status report has been sent from the Court of Additional District and Session Judge Nagaon. But surprisingly, as per the report of the learned special judge, the CD is not available with the case record, and it is stated that the investigating officer did not submit the CD in connection with this case at the time of filing charge sheet, and hence the scanned copy of the CD could not be furnished before this court. In that context, Mr. Busher submitted that the 3 PWs has already been examined by the learned special judge, and without in absence of the case diary, wherein the statement of the witnesses were recorded under section 161 CRPC, which may be required. No, CRPC, not it is also seen that before submitting the status report by the learned additional district and session judge number 2, Nagaon, the court did not make any inquiry in regards to non-availability of the case diary along with the charge sheet, nor there was any endeavor to collect or to obtain the CD from the concerned police station or from the investigating officer. Without a available statement. So 161 are not here.
No, my lord, because my lord, CD is not available, my lord.
But without without statement recorded under section 161 CRPC, the witnesses were also examined, which is without any examined, which is otherwise required for any contradiction or corroboration purpose. In view of this, the learned court below is hereby directed to obtain the case diary from the concerned police station public investigating officer and to send the scanned copy of the case diary immediately before this court without without anything. On or before the next next date of listing without any delay, without further delay. The registry will do the need in communicating the learned court below, and the order of this court may also be accompanied along with the notice to be issued to the learned additional district and session judge number 2. List the matter accordingly.
Next week, Lord.
Next week for the court, it may not be possible, I think. Next week may not be possible
Yeah.
for the court because he has to make communication with the concerned police station or IO, then only it may be. So let it be on the second week of December, I think.
Maybe on 8th, your Lord. Monday, 8th.
8 is another problem because 2 days there is a holiday, so communication you may not
Yeah,
reach also.
yeah.
Let it be on 10 only. 10 will be all right, I think. 10 only.
It will
May I please, your Lordship?
Yes.
Lordship, this is a case of Lordship, commercial quantity Lordship, NDPS Act Lordship. There are two petitioner in this case, Lordship. Petitioner number 1 is behind the bar since 213 days, Lordship, 213 days. And petitioner number 2 behind the bar since 140 days. He was arrested later on, Lordship. Nothing has been recovered. From
200 and
petition number 1, 213 days, Lordship. And
petitioner
petition number 2, 140 days. And the petitioner number 2 was arrested later on and nothing was recovered from his possession. In this case, Lordship, we have filed the present petition, Lordship, on the violation of Article 22, Lordship, this grounds of arrest, Lordship. And we have annexed the notices under section 47 and 48, Lordship, in respect of both the petitioner, Lordship. And the notices are starts from page number 48, Lordship, of the present petition. Notices start.
this has already been charged sheet.
Yes, Lordship.
Notices page.
Charge pay what? Charge was not yet paid.
Charge not yet paid.
Yes, Lordship. Lordship, the recovery was, Lordship, the tramadol tablet, Lordship, 3020 grams, Lordship, including the weight of the strip, Lordship. Lordship, may kindly come to page
48 is the notice 47 under section.
Yes, 47. For notice 47, it is in respect of the petitioner number 1, Lordship. Aminul Islam, Lordship. Lordship, page 50 is the relevant portion, Lordship, where grounds of arrest are stated, Lordship, in a vernacular language, Lordship. There are 6, they have given 6 points for grounds of arrest, Lordship, but nothing has been stated that what has been recovered, in what quantity has been recovered, when has been recovered, nothing has been stated in the notice, which is a mandatory requirement as per the observation of the Honorable Supreme Court in the case of Pravir Purakaista, Lordship. The basic fact which necessitate the arrest of the present petitioner, Lordship, that has not been stated in the notice, Lordship.
And for number 2,
For petitioner number 2, Lordship, page number starts from 52, Lordship. That is also 47 notice of the petitioner number 2, Lordship. And page 53 starts from 52 only, Lordship. The lower portion, grounds of arrest, in the vernacular language, Lordship. 52. Herein also, Lordship, nothing has been stated and what has been recovered in this case, Lordship, and why his arrest is necessitated, Lordship, in what condition the contraband was recovered, and what was the actual contraband, that is also not yet been stated, Lordship, in the notice, Lordship. The basic facts of the case, Lordship, not has been given.
Yes.
Lordship. As per Lordship,
Charge not yet framed, na? Charge not yet framed.
not yet framed. As per constitutional and statutory mandates, Lordship, the arrested person must be informed of the ground of arrest. As per the statutory
Para,
constitutional provision.
yeah.
So under Article 22, one of the Constitution of India that mandates that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of for such arrest, and nor shall he be detained the right to consult and to be defended by legal practitioners. Similarly, Section 7 of BNSS, which is equivalent to Section 50 of CRPC, requires that every police officer or other person arresting any person without warrant forthwith communicate to him full particulars of the offense for which he is arrested or other grounds persons like. That is a mandatory provisions under constitutional as well as statutory. Lordship, the constitutional and statutory framework mandates that the arrested person must be informed of the ground of arrest, but neither provisions prescribe a specific form or insist upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstrable prejudice is caused to the accused. In Bihankuma versus State of Haryana, it was relied that the Article 22(1) is satisfied if the accused is made aware of the arrest grounds in substance, even if not conveyed in writing. But here in this case, Section 47-48 is specifically complied with by giving the reasons whatsoever, which made him aware that he has been arrested for a crime under NDPS. Again, while Section 47 of BNSS is mandatory, the consistent judicial efforts has been to adopt a prejudice-oriented test when examining any procedural lapses. So in the present case in hand, Lordship, arrest memos, remand records, including the notices under Section 47 and 48 of BNSS, it reflects that the accused petitioner was aware of the reasons for their arrest. That is very much it. They applied for bail after arrest and no materials has been placed on record till date to establish that any prejudice was caused due to the alleged procedural lapse. That is, the seized contraband that has been recovered from the present petitioner is not even the specific amount. Only because of that reason, bail cannot be granted to the petitioner. In the absence of demonstrable prejudice, such as irregularity, procedural lapses at best a curable defect and cannot by itself warrant release on bail. It cannot be a determinative factor why the court has to consider a bail application involves a serious offense that to under Section 22C of the NDPS Act and the existence of a prima facie case. Otherwise, it is recovered from their conscious. The settled principle is that procedural lapses in furnishing grounds of arrest, absent prejudice, do not ipso facto render custody illegal or entitle the accused to bail. That is beautifully explained in the very Lordship famous judgment. The Lordship is already aware. State of Karnataka versus Nidarshan, etc. I would like to draw your Lordship's kind attention to the judgment of Lordship. Para 21.7. Has your Lordship. In the present case, in our case, the arrest memos, the remand records, as well as 47, 48 notices The respondents were aware of the reasons for their arrest. They were legally represented from the outset and applied for bail shortly after arrest. Evidence has immediate and informed understanding of the accusations, and no material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapses. That is, in 47 notice, the specific amount that has been recovered from the possession of the petition, that is not only for that reason, and to that ground, they have not taken any lordship, they have not filed any applications before the court that it's been prejudiced by the technical errors of the lapses of the investigating. And thereafter, lordship, in the absence of demonstrable prejudice, such as irregularity is at best curable defect and cannot by itself warrant release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the charge under Section 282. Here in our case, 22C of FTS involved. And here is the prima facie cases otherwise established. Thereafter, the last paragraph, the approach adopted here is inconsistent with the settled principle that procedural lapses in furnishing grounds of arrest, absent prejudice. Here, there have been prejudice that is absent and do not ipso facto render custody illegal or entitled. This is my humble submission, otherwise sufficient. Ample awareness is, he is aware of the fact that he has been arrested. Thereafter, he has not taken any ground that he has been prejudiced by the technical lapses of the contract. That cannot be drawn. This is my.
May I submit with list? This is regarding the judgment person, Lordship. The prejudice. Lordship, the judgment person judgment come later on, Lordship. Bihan Kumar come first, Lordship.
Here also,
And-
Bihan Kumar is also this.
Yes, Lordship. And as per Lordship, Bihan Kumar, Lordship, the grounds of arrest would be given to the arrested Lordship in writing, Lordship, in a language which he understood, Lordship. And judgment Provipukasto, Lordship, there are 49, Lordship, that given the actual meaning of the grounds of arrest, and the difference between the grounds of arrest and the reason of arrest. Grounds of arrest should be given to the accused, the spirit of behind this Lordship, so that the accused can avail Lordship proper defense, Lordship, for himself, Lordship. In our notice, Lordship, if the contraband is not mentioned, Lordship, what circumstances it is not mentioned, Lordship. Suppose, Lordship, contraband is seized in Guwahati. Is suppose the present petitioner was in another city, Lordship. If it would have been basic fact, would have there, Lordship, then the petitioner may have taken the proper, Lordship, defense for him, Lordship. And in legal point, Lordship, I would like to submit, Lordship, that the division bench of our court, Lordship. And one, there is two judgment of Supreme Court, Lordship. The earlier should be followed, Lordship. The National Investigating Agency, I'll furnish the order also, Lordship. The criminal appeal number, Lordship, I'll furnish, Lordship. The earlier judgment should be followed, Lordship. And in regard to the Lordship, that he has filed the petition for bail and Lordship, he was represented by counsel, Lordship. The recent judgment of Honorable Supreme Court, the Ahmed Mansoor case, Lordship. In that case, Lordship, the grounds of arrest were explained by the court itself, Lordship, and copy of the same, Lordship, provided to the counsel representing, Lordship. In that case also, Lordship, Honorable Supreme Court held that there is a violation of the Article 21, Lordship. The grounds of arrest was not complied properly, Lordship. And in very recent judgment, Lordship, in this month, Lordship, November, Lordship, this Mihir Rajesh Shah, Lordship, Supreme Court again finally held that the grounds of arrest should be given to the accused person in writing, Lordship. But in some situation, Lordship, where the arresting authority cannot give, Lordship, in writing at the time of arrest, Lordship, in that case, Lordship, they have to give them grounds of arrest orally, and before production, at least before 2 hours of the production before the court, Lordship, the grounds of arrest should be provided in writing to the arrest. At present, Lordship, the settled law is the grounds of arrest should be given, Lordship. That is, Lordship, my humble submission. I may allow to submit the relevant judgments, Lordship. I'll
Within
today.
today means we are going going to dictate the order, so just pass the.
Yes.
I'll go dictate in my chamber, so you just hand over the.
Yes, Lordship. I'll hand over the judgment highlighting the 11 para. And one more, Lordship, thing to be point out, Lordship, in the 48th notice is also one more point, one more thing to be point out, Lordship. The 48th notice of petitioner number 1, Lordship, page 54, Lordship. If Lordship kindly may see, Lordship.
Yes.
Page 54, Lordship, the notice is addressed to the accused himself, Lordship. To Aminur Islam. That is 48th notice. It must have, Lordship, addressed to his nominated person, Lordship, or family member, Lordship. In respect of petitioner number 1, Lordship.
After the signature of the informed person is there.
Yes, Lordship. That is all. That is Muslim Ali is there, his maternal uncle. I am
Yes,
addressing
Lordship,
there.
that is there, 55. Wait.
But it is addressed to
And I would
Aminur Islam.
also like to draw your Lordship's kind attention to. Okay, Lord.
50. Yes.
Round number 2, Lordship.
Hmm.
May read, Lordship. পুনাৰ বিৰুদ্ধে গোচৰটোৰ সৈতে জড়িত হোৱাৰ সন্দৰ্ভত পৰ্যাপ্ত পৰিমাণৰ প্ৰমাণপত্ৰ গৈছে যে যিখিনি নিৰ্ধাৰিত সামগ্ৰী আপুনি লুকুৱাই লৈ কৰিছিল হৈ আছিল জব্দ তালিকা অনুসৰি একেখিনি বস্তু আপোনাৰ হাতৰ পৰা জব্দ কৰা হৈছে এজ পাৰ দ্য সিজাৰ লিষ্ট So seizure list is Lordship kindly come to case 31. It has been specifically mentioned that the articles has been recovered from his possession and that his endorsement is at case 32. Lordship kindly. What else is required?
Otherwise, Lordship, in every season list, there is a thing. The investigating
else is
agency used to took the signature of the accused.
This is my humble. Okay.
Okay.
God bless.
Nine, we have received this scan copy.
My lord, we have received the scan copy.
Huh.
My lord, that is the scan copy. My lord, CD is not available. My lord. Now, my lord,
Again, CD is not,
my lord,
but they are not, they
my
are
lord,
not appearing.
they needn't appear. And my lord, my lord, may kindly produce the order that is 411.
411.
411.
Yes.
Yes, my lord. 411. My lord, one submission is there. My lord, that is success submitted. My
No, that's why prosperity is here.
lord. My lord, that was called for. But my lord, we have a communication earlier on my lord 21125. My lord. And as per that communication, my lord, at that point of time on 21125, my lord, my lord, that is available with our office, my lord, the city. Then, my lord, if my lord on that 211, my lord, that is, or my lord, the submission maybe some, my lord, things may be there. I made a communication to our office also, my lord, to find out the thing, whether city is available, whether search sheet is filed, because there, my lord, search sheet order is also not mentioned, my lord, in 411 order. And my lord, going through the PCR, my lord, I didn't get anything, my lord, which records that my lord CS is filed or anything. Even the city is also not available. In this matter, my lord, allow us to make a matter query whether my lord CS is filed or my lord, if CS is filed, what is the CS number and what is the exact status?
None appears on call for the petitioner. Heard Mr. K. Bosha, the learned edition PP, appearing on behalf of the- It is submitted by Mr. Bosha that though it was submission from the petitioner that this case has already been charged, but he did not charge sheeted, but he has no communication from the IO concerned IO as to whether the case has already been charge sheeted or not. In view of this, he takes time to make to take instructions by instructions from the IO in regards to filing of the charge sheet. List the matter accordingly. After 1 week, he is not appearing.
Immediately we will take my lord. And my lord, if my lord is
As
not
related
charge
to
sheeted,
the
my lord, then for CD my lord. If not my lord,
And they are absent.
yes. We'll take them as instant.
Instant.
Fine.
Here is the office note, I think.
Yes, my lord.
Yes.
May I please, Your Lordship?
Yes.
My lord, though, my lord, I think that we have inquired in the morning. My learned friend said CD is not available.
My lord, CD not available, and my lord, it
Now,
is
what
my lord,
about the service?
no matter,
order?
my lord. I have come through the office note, my lord.
Huh.
My lord, that is my lord, order was passed on my lord 4/11/25 for the notice, my lord. Then thereafter on 17/11 they took the step, my lord. The
Huh.
copy from our office is there, but my lord, the service is available. Let us, my lord, take the instruction regarding the service of notice.
My
And
lord,
same
And
time,
CD is not available.
CD
it
not
is not
available.
available, my lord, and the service is also awaited, my lord.
No, that is correct, my lord. But on the other hand, my lord, if you go by the mandatory period of detention, my lord, today I have
Enabling the learned additional PP to go through this can possibility. So we are listing it on 212.
Obliged, madam.
Okay.
Deeply on that.
Okay.
Well, that's my lord, CD not received, my lord.
Yes, Your Honor, 82 days behind bar, Your Honor, 90 days offense, Your Honor. Kindly consider
Short
the
date, my lord.
land
Very short
petition.
date, my lord.
What is the offense, in fact? 90 days offense.
Yes, Your Honor, 3314, 305 and 317, Your Honor. Starting house trespass and theft in dwelling house.
Acha. So your petition is in 82 days.
Yes, Your Honor.
When it can be, from where it has to come?
My lord, it is from short February, my lord. Short date, my lord.
Short February.
Short, no, short date.
I cannot
We didn't do that. We take money. COVID. Second,
Second,
oblige.
you are MSP
Equally.
Colita, hard MSP Colita, the learned counsel for the petition. Also heard Mr. K. Bush and a petition PPA. CD not received, issue reminder, list matter.
April.
And his up to deal. Dictation. So, having another bench, question no.
No, my lord, one I had already, my lord, completed today.